And the gentlewoman from California, Ms. Sanchez.
Thank you, Mr. Chairman. I note with some degree of amusement the exchange that has been going on regarding cases of summary judgment. Summary judgment can be granted in cases in which there's no dispute as to the facts, but in which case plaintiffs are trying to assert a novel or interesting new theory of law and apply the facts to that law. So not all summary judgment motions that are granted are necessarily frivolous lawsuit. In fact, that is how our common law case system moves forward with novel questions of law, is when interesting situations come up that don't fit the traditional fact pattern, but in fact makes way for new law. For example, things like palimony, which didn't used to exist until somebody asserted a novel theory of law that if somebody fathered a child, they could be, in fact, sued for palimony or monies awarded to help raise that child. Many novel questions of civil rights or anti-discrimination laws didn't fit the traditional fact patterns until those cases were brought. Having them before a judge, the judge saw the need to move the law forward in a way that changed the law therever after, Brown versus Board of Education being a very good example of that.
Would the gentlelady yield for a question?
I will not. You've had time, and I want to make certain points. If the point of the changes to Rule 11 are to try to dissuade people from litigating, in fact, what this does without giving discretion to the judges or giving a safe harbor provision, what it actually does is encourage attorneys to dig in their heels and to litigate to the death, so to speak, when these Rule 11 issues come up, because they will not be trying the cases, they will be trying to try the attorneys. And I think looking at some of the information with respect to federal judges who were surveyed, 91% opposed the proposed requirement that sanctions be imposed for every Rule 11 violation. That means that 91% of judges sitting currently on the federal bench don't think that the sanctions should be mandatory, because they don't think that is helpful. And in fact, if you look at the proposed changes and the 1983 rule, a whole cottage industry of Rule 11 litigation mushroomed after that rule change, because people were trying to harass and intimidate parties in a lawsuit by going after people for Rule 11 sanctions. So if the point of the proposed bill is to curb frivolous litigation, it's not going to do anything of the sort. Without the safe harbor provision and without some discretion by judges to impose sanctions when and where they think it's necessary, and it might be surprising that many judges don't think that things warrant sanctions, but that doesn't mean that they're wrong. You may disagree with them personally, but that doesn't mean that somehow in the universe, because we can't cite a single case of a summary judgment motion that was accompanied with Rule 11 sanctions. I bet there probably is a case out there. I don't happen to be familiar with it, nor are my colleagues on a moment's notice. But that doesn't mean that there is a problem here. And I keep going back to the people who interpret and apply the law. If they don't see this as being beneficial, I don't understand why Congress is meddling and mandating that this happen. Again, I think we should leave the application of the law to those who have been entrusted to uphold it, and we should respect the fact that 91% of them oppose the requirement that sanctions are imposed without any discretion, and the fact that a whole cottage industry of Rule 11 litigation will follow it. Again, if the goal is to reduce litigation, you're not doing it with this bill without Ms. Jackson-Lee's amendment. So on that note, I will yield back my time to the chairman.